Let me do this right. President of AmCham Trinidad and Tobago, Patricia Ghani, members of the boards of AmCham Trinidad and Tobago and the CCGI. Our guest feature speaker, Ms. Debra Bharat Thompson, Ms. Fanta Punch, guest panelists Angela Leloy and Donna Marie Johnson, our moderator, Mr. Nigel Romano, who's a director of the CCGI, members of the CCGI and AmCham Trinidad and Tobago, ladies and gentlemen, specially invited guests, good morning. My job this morning is simple, is to keep the program moving. I've been told to keep it short and sweet for a change was added. So I'll try and do that. Just to say that AmCham Trinidad and Tobago is happy to be partnering with the CCGI on this. As you should know, I hope, our focus, one of our areas of focus has been historically on combating white-collar crime. In the whole crime discussion, sometimes we forget that, and we think it's absolutely important that we deal with white-collar crime if we're going to fix some of the systemic issues facing Trinidad and Tobago, particularly as it relates to crime and the ease of doing business, as adequate rule of law is essential to attracting investment and doing business effectively. So we welcome this. We hope that it educates our members and members of the business community on some of the requirements, but we also look forward to hearing some of the solutions to the implementation issues that remain with this piece of legislation. So with that, it's my pleasure to introduce the CEO of the CCGI, Ms. Kamala Rampersad De Silva. I'm advised that detailed bios are in your agenda, so I will not be going through them, and I don't think Kamala needs much of an introduction, so I introduce her to do the welcome remarks.
Thank you very much, Nirad. Good morning, everyone. All protocols observed, but I do want to say a very, very special thank you to our guests, presenters, and our panelists for today. I really am looking forward to today's session. As a matter of fact, when Faye and I met with Mrs. Debra Bharat Thompson a few weeks ago to plan the agenda for today, we challenged ourselves to fill this room because we recognized how very important this topic is. We are very pleased that you too all recognize the importance of this change and that you have come out in your numbers here, so we have been able to fill the room. So thank you all very much. Together, we will try to arrive at a better understanding of what changes government has brought forward, why this change has occurred, and most importantly, how we all comply to this new law. Understanding the changing external environment is important and is in line with our purpose at the Caribbean Corporate Governance Institute to help improve our corporate governance landscape. Incorporated as a not-for-profit membership organization in 2012, the Caribbean Corporate Governance Institute is dedicated to advancing principles of corporate governance across the Caribbean. The CCGI has no political or religious affiliation or activity. CCGI operates autonomously and is not controlled by any single external governmental, business, or commercial interests. Our vision at the Caribbean Corporate Governance Institute is to be the leading non-profit professional membership organization serving directors and investors in the region, individually and collectively, bringing about effective organizations and efficient markets in the Caribbean. CCGI's mission is to promote world-class transparency and competitiveness for companies in the region through the promotion of leading corporate governance practices, education programs, corporate governance guidelines, networking, linkages with regional and international bodies, and by providing counseling on corporate governance and related matters. Today's session will focus on compliance with the new law, which is an important part of the function of the Board of Directors. I wish to thank Mr. Glenn Hamilsmith of AmCham TT and Mrs. Faye Lopez-Colomore, our director at CCGI, whose idea it was to have this session. And also I would like to thank Nirad and the Board of Directors of AmCham TT for agreeing to collaborate with us to help make the session happen. Improving corporate governance practices benefits the entire society, and we are happy to work together to help in transforming this environment. At the same time, I want to take this opportunity to share with you some more upcoming activities we have at the CCGI. So, on September 5th, just a few days away, we have a one-day workshop which we have planned to fully explore and engage in the duties of directors. This seminar, as some of you in this room would know, is a follow-up on two very successful breakfast seminars with spotlight on the duties of directors and the impact of recent court cases and the decision of the Privy Council, which were discussed right here at the Hyatt. For that one-day workshop, Dr. Terence Farrell will be a key facilitator, along with the chairman of our board, Mr. Ronnie Bisassa. They, along with Faye and myself, will be discussing the duties of directors, how the court interprets and applies directors' duties, as well as the difference between management and governance. Dr. Farrell, too, will facilitate on the issues and challenges with governance of state-owned enterprises. So this workshop will be held at the Trinidad Hilton on September 5th. Registration is open at present, and I will tell you that space is limited. Also, in September, on the 7th, we intend to have another breakfast seminar right here at the Hyatt. And this time, we'd be looking at the role of the chairman of the board. I am sure you will agree that this is a very timely issue. Now, some of you here would recall that for our first breakfast seminar in August, we had closed off registration within a few days because of the number of responses that we got. This time, too, we have only been able to secure a small room at the Hyatt. Therefore, if you want to be present for that seminar, it is important for you to register early. Registration is already open for that seminar. Further along, on September 26th, you can look out for an invitation from us jointly with the Arthur Lockjack Global School of Business to attend the launch of their second annual ranking on the disclosure and compliance of publicly listed companies. The initial ranking done in collaboration with the Rotham School had generated a lot of interest last year. In a discussion yesterday with Dr. Ron Sukram of the Lockjack GSB, he advised that there has been significant improvement in disclosure by some companies in this last year. So you can look forward to the results. This launch will be held at the Yara Auditorium at the GSB, and it will be free of charge. However, you will need to register, and the registration will take place via CCGI's website. So you can look out for your email from us. Now, at the moment, we have no planned activities for October. However, we know that Aegis will be holding a conference, a corporate governance conference, later on in October. So Ms. Angela Leloy is here. She would be one of our panelists, and I'm sure she will share some more details on that conference. But I'm saying at the moment, there are no planned activities, right? Faye will tell you we have been keeping it, really busy, and many of you have been present for, we've had 3 sessions within the last month, so just in case. But finally, what I wish to share is we are putting the final plans in place for a series of programs in the week of November 18th to 22nd. This will include a master class as well as 2 of our corporate governance modules. So within a few weeks, we would be sending details of this to you as well, so you can plan your time. Finally, I would like to reiterate our invitation to you to join us. As a membership organization, we have both organizational and individual membership subscriptions, details of which are now available at the back of your agenda. So, there's much we can do together to improve our corporate governance landscape. We look forward in the future to more collaborations with organizations like AmCham TT to serve our members and all those who are looking to improve corporate governance in the region. Thank you so much, and I look forward to learning a lot today.
Thank you, Kamala. And I guess it would be remiss of me not to talk a little bit about one of our events as well, which is our upcoming HS S&E conference on October 23rd and 24th, where this year we'll be having a session on directors' liability as it relates to HSSE risk. So that's something that people have been asking for, and details on our website, amchamtt.com. But up next is Fanta Punch. Her bio is in there. Fanta has a wealth of experience in matters related to corporate law. So I invite Fanta Punch to come and whet our appetite, as it were, with regard to the Act.
Good morning, everyone. Thank you, Narad. I know that our focus today is on beneficial ownership, more particularly in the context of the recently passed Companies Amendment Act, which Mrs. Thompson will touch on. I want to this morning give a very brief background and history into the anti-money laundering, financing of counterterrorism regime of laws in Trinidad and Tobago against the background of obligations for compliance with international standards to effectively deal with money laundering and financing of terrorism. It could be said that the well-known scandal, the Panama Papers, of which we are all familiar, was a trigger for international focus on beneficial ownership and the difficulties in tracing the real owners and shareholders in companies who were able to hide their criminal activities behind the veil of a corporate structure. I think it's worth mentioning as well what the concepts of money laundering involve and financing of terrorism, to give some insight as to how and why knowing who the beneficial owner is important. A definition of money laundering, or it could be said that it is the taking the proceeds of criminal activity and corruption and converting them into clean or legitimate assets. Conversely, anti-money laundering refers to a set of procedures, laws, or regulations designed to stop the practice of generating income through illegal actions. Terrorist financing is about providing money to facilitate terrorist activity, and that could involve funds raised from legitimate sources such as personal donations and profits from businesses and charitable organizations, as well as from criminal sources such as the drug trade or smuggling of weapons and other goods. There are a number of international and regional bodies established to implement and monitor effective prevention of money laundering and financing of terrorism around the world. Regionally, we have the Caribbean Financial Action Task Force, which as some or most of us may already know, established in the early 1990s, has as its mandate the implementation of the recommendations of the International Intergovernmental Organization, the Financial Action Task Force, or FATF as it is referred to, which itself was established in 1989 and sets the standards to promote implementation of legal, regulatory, and operational measures to combat money laundering, terrorist financing, and other related threats to the international financial system. FATF had set out some 40 recommendations, which I will refer to as the FATF recommendations, which are meant to be implemented globally to ensure that all its members are fully compliant with AML CFT regulations and obligations. The Caribbean Financial Action Task Force, in its role, has rated Trinidad and Tobago's compliance with these FATF recommendations as recently as 2016 in its Mutual Evaluation Report for Trinidad and Tobago. Now, as a member of the Caribbean Financial Action Task Force and the current host of the Secretariat here, Trinidad and Tobago is obligated to comply with the recommendations and to not only enact relevant legislation, which we will be looking at later today, but more importantly, to take the necessary steps to enforce those AML and CFT laws. In my opinion, and I hope others may agree with me, I think that Trinidad and Tobago has had a fairly long history of difficulty in meeting some of these FATF recommendations. At present, our country, along with others like Pakistan, Syria, and Botswana, and Yemen, have been identified by FATF as having strategic deficiencies in their or in our AML CFT regimes. Non-compliance has potential consequences for our local banking institutions in their relationships at the international level with other financial institutions. It can handicap our ability to trade internationally, affect our international ratings, and deter international investments, all of which can negatively hinder and could be, it's arguable that it has already, the economic and social stability and growth of our country. Notwithstanding all of that, we do have in place a regime of AML CFT legislation. The list is fairly long, but in summary they include, and I'll just mention, the Financial Intelligence Unit of Trinidad and Tobago Act, which regulates the powers and authority of the Financial Intelligence Unit, which is the regulator governing all AML CFT laws. There's also the Financial Intelligence Unit of Trinidad and Tobago regulations, Financial Obligation Regulations, Proceeds of Crime Act, and Anti-Terrorism Act, and there have been subsequent amendments to these pieces of legislation. The entities charged with ensuring that the implementation and measurement of money laundering and terrorist financing for the international standards that are set by the FATF recommendations are mainly financial institutions and listed businesses. Listed businesses can be defined, and they are defined in the Proceeds of Crime Act, as including realtors, motor vehicle dealers, gaming and pool betting operators, also jewelers, attorneys, accountants, private members units. Those are some of the entities that are classed as listed businesses. Now, I need to make the point here that even though the list or type of entities are deemed to be listed businesses, and that doesn't include every single type of company or business, listed businesses are really seen to be the gatekeepers of the AML CFT regime. As such, as part of their due diligence, they are required to obtain information on clients, including companies, and that information will include beneficial ownership. So I just want to make that distinction. As I mentioned above, in 2016, the Caribbean Financial Action Task Force, in its Mutual Evaluation Report on Trinidad, assessed our level of compliance with FATF's 40 recommendations and identified a number of areas for improvement in Trinidad and Tobago, some of which are better understanding and assessment of risk, improved legislation to allow law enforcement to gather financial intelligence, confiscation of illegal assets and legislation that will address that, improved legislation for terrorist financing, AML CFT policies and laws to deal with non-profit organizations, and improvements in the maintenance and accuracy of information at companies, in particular beneficial ownership information, with recommendations for amendments of our Companies Act. The report did also note that the central bank in particular already has in place a very robust suite of laws with adequate supervision, which has been developed over time, and that's understandable as the central bank has a lot of experience in this area. Coming out of that 2016 report, the government has sought to address some of those recommendations, and I would like to name two of them. One is the recently partly proclaimed Non-Profit Organizations Act, or the NPO Act as it is sometimes loosely called. It requires non-profit organizations to register with the Registrar General's Department. Previously, there was no requirement to do that, and there were no AML-CFT policies in place to monitor these activities. Without this law, it would not be possible to find out about terrorist financing or money laundering activities that they might be involved in. I want to just tongue-in-cheek say David Carew and leave that there. The second one is the Civil Asset Recovery and Management and Unexplained Wealth Act, or the Unexplained Wealth Act. This act also is not fully proclaimed, but will be addressing mechanisms for recovery of properties and assets secured through criminal activity. Now to beneficial ownership. Before the Companies Amendment Act, the current Proceeds of Crime Act touched on beneficial ownership, but not in a real significant way. Hence the Caribbean Financial Action Task Force recommendations. Recommendations 24 and 25 of that report deal specifically with transparency and beneficial ownership of legal persons, and transparency and beneficial ownership of legal arrangements, with details on what is required to become fully compliant. As it stands today, Trinidad and Tobago remains not fully compliant with the international AML-CFT standards, and at its most recent report on this country in June of this year, FATF still rates us as a high-risk monitor jurisdiction. Its report notes, and I quote, "Since November 2017, when Trinidad and Tobago made a high-level political commitment to work with the FATF and the Caribbean Financial Action Task Force to strengthen the effectiveness of its AML-CFT regime and address any related technical deficiencies, Trinidad and Tobago has taken steps towards improving its AML-CFT regime, including by proclaiming laws on non-profit organization supervision and civil asset recovery. Trinidad and Tobago should continue to work on implementing its action plan to address its strategic deficiencies, including by implementing 1, the remaining measures to further enhance international cooperation, 2, the issues related to transparency and beneficial ownership, and 3, measures to monitor non-profit organizations on the basis of risk." That said, the recently passed, end quote, my apologies. That said, the recently passed Companies Amendment Act is a step in the right direction. I will now pass you on to Debra, who will deal with this in more detail. Thank you.
Thank you, Fanta. Thank you, AmCham board members, and thank you, CCGI. Thank you all for coming here this morning and opening your minds up to this new development in our legislative framework, which is very important for all of us. As you would have heard from Fanta, in its efforts to conform with international standards and obligations in respect of combating money laundering and the financing of terrorism, our government has identified various anti-money laundering and counter-terrorism measures. And its efforts to raise our level of compliance with the task force, Financial Action Task Force, we've beefed up our legislative and regulatory framework. Because Trinidad has traditionally been a hub of commercial activity, one of the areas that was focused on is the Registrar General's Department, which is responsible for, as you would know, incorporation of companies, registration of business names, and dealing with non-profit organizations. And it was seen as an area where information could be gathered on beneficial owners. Now, prior to the amendment, very limited information was required by the Registrar General's Department in terms of companies. So on registration, the name and address of the incorporator would have to be provided. In terms of annual returns every year, information on directors and secretary and assistant secretary would need to be provided. After incorporation and having an organizational meeting, further limited information would be provided on registered shareholders. And in terms of a company having a unanimous shareholders agreement, notice of that shareholders agreement would have to be given, but not details of it, so there was no details behind it. Now, any member of the public could access this basic information by going on TT BizLink, for example, and accessing the database records of the Registrar General's office and getting access to this basic information, which, I mean, it has been useful, but it's basic information. And it was thought that this is not enough information, and therefore, in order to further comply and bring us in line with the recommendations of FACTAF, the amendment was passed on the 29th of May this year, bringing into force, full force, the amendments to the Companies Act. The main aim of the amendment was to ensure that the ultimate beneficial owner of a company are disclosed in the company records and recorded in the company's registry. The amendment also it prohibits the issue of bearer shares, bearer share certificates, share warrants, and bearer share warrants for companies. What I'm going to talk about today in this address is the ultimate beneficial owner and the far-reaching obligations and penalties that are now imposed for non-compliance. And we're going to look at how they can affect small and large companies alike in Trinidad. I will also touch briefly on some other jurisdictions just to see what they've implemented and how they are also trying to comply with their relevant legislative framework. So who must comply with these obligations? Well, firstly, the most significant and critical change is the introduction of disclosure and reporting regime in respect of beneficial owners in locally incorporated companies. The amendment places obligations and criminal penalties for failing to comply. And the persons that are affected are the company itself, every director, every shareholder, and officers of the company. So this means the chairman, the deputy chairman, the vice president, managing director, the general manager, and of course, beneficial owners. All of these are required to comply and will be penalized if they don't. Who then is the beneficial owner? The Act has defined the beneficial owner, Right, so the Act defines the beneficial owner as that natural person on whose benefit a transaction is being conducted, or the natural person who exercises effective control over the legal person of the organization. And in respect of a company, it's the natural person who ultimately owns or controls the company, and that can be either directly or indirect ownership or control. If there's no natural person, it is the person who exercises control over the legal person in the company. And if there's no such person, again, it goes further to say, then it is a natural person who holds the position of senior managing officer of the organization. In terms of trusts, it's the trustee or the beneficiary or class of beneficiary or any other natural person who's controlling the trust. So in plain terms, the beneficial owner is that natural person who is the ultimate owner of the asset, and that's the individual who typically enjoys the benefits of ownership. And in circumstances where he cannot be identified, it's the natural person who exercises control or direction over a company. Now let's look at companies first of all, and then we'll separate out beneficial owners. So let's just look at the obligations on companies. Every company is now required to actively ascertain and obtain information as to all persons who hold beneficial interests in the company. According to the amendment, the obligation is to be effected within 12 months of coming into force of the Act. And remember, this was proclaimed on the 29th of May this year. But I want to stick a pin there in terms of that timing. So, in addition to ascertaining this information, or in an effort to ascertain this information, the company has to issue a notice to all of its registered shareholders, requiring them to submit a declaration. And in this declaration, they need to advise that the share is held in their name and whether they are the beneficial owners or not. So if they're not the beneficial owner, they then have to name in that declaration who the beneficial owner actually is. The company then needs to maintain a register of all of the beneficial owners from the information which is received in those declarations. And then, within 30 days of receipt of the declaration from its shareholder or the beneficial owner, it then has to deliver a return to the company's registry in the prescribed form, and this has to be certified by a director or officer of the company. Those are the obligations for the company. The beneficial owner also has obligations. Each registered shareholder of an incorporated local company who is not the beneficial owner has an obligation to submit his own declaration to the company within 30 days of the commencement of the Act. The Act was proclaimed on the 29th of May. So that means, as at the end of June of this year, all registered shareholders who are not beneficial owners should have submitted these declarations. And this is where there's a little bit of play in terms of what is the timing in terms of enforcement. Because the company, as you heard previously, is supposed to issue a notice, but it's only on receipt of that notice that the registered shareholders complete their declaration. So the reality is, whilst the Act says there's 1 year in order to gather the information, in order not to expose your shareholders and your beneficial owners, those notices should have been issued as soon as the Act came out at the beginning of June to allow your shareholders and your beneficial owners to comply with their obligations and their requirements. So back to the beneficial owners. So the beneficial owner who's not the registered shareholder who's not the beneficial owner submits the declaration to the company. He has to state the capacity in which the shares are held and identify the person who is the beneficial owner. Any person who held a beneficial interest prior to the Act coming into force also has an obligation to fill out a declaration. Anybody who acquires a beneficial interest in a share in a local company is required within 30 days of acquiring that share. Where that person is not the registered shareholder, they have to state the nature of their interest, the particulars of the person in whose name the share is registered, and the date on which the beneficial ownership was acquired. If there are any changes in any of the information disclosed by a shareholder or a beneficial owner, they are required to submit a declaration to the company specifying the nature of the change. So any change in shareholding in a company will be caught by this requirement to submit a declaration. Penalty. What are the penalties? A company that fails to take steps to ascertain the information in respect of its beneficial owners and/or to fill out any annual return is liable on summary conviction to a fine of 10,000 TT dollars, to imprisonment, and a further fine of $300 per day that the offense continues. And this means that it's the company, each of its directors, and officers that are potentially liable to committing an offense and being fined and exposed to potential imprisonment. Now, there's no specific penalty for failure to establish the register that I spoke about previously. But in having a register there, if your company is ever audited, that would be one step in the direction of showing we took the steps to try and gather the information that was required, and we did all that could have been done reasonably. Failure to make the required declaration by a beneficial owner will result in that beneficial owner being stopped from enforcing his rights or interests in relation to his or her shares. But that does not affect his right to dividends. Now, for the purposes of identifying beneficial owners, a company is entitled to rely upon declarations received by it in good faith from its shareholders, unless the company has reason to believe that the declaration was misleading or false. Now, are all companies required to comply with the Amendment Act? The Amendment Act applies to companies that are incorporated in Trinidad and Tobago. So in the Act itself, it defines company as an act which was incorporated in Trinidad and Tobago. So therefore, by definition, external companies that have branches registered in Trinidad and Tobago are not really caught by the Act, because it says companies that are incorporated in Trinidad and Tobago, and an external company is not incorporated, it just has a branch that's registered here. Also, companies that are listed and publicly traded on the stock exchange are specifically excluded from the Act. Companies that are also listed on a regulated market, for example, of the financial institutions, these are also excluded under the Act. How far then should a company go to determine who its beneficial owners are? Let's say, for example, a company has issued a notice and there's no response. is that suffice to do nothing? In order to show that reasonable steps have been taken, it may not be suffice just to issue a notice to your shareholders. It may be wise to follow up and have a record that you followed up. You send maybe another notification by registered mail, a telephone conversation, but you keep a record of it. Because in the absence of such record, you always want to be able to show that steps were taken. As I said before, the company is entitled to rely on the declarations received in good faith. But if they're aware that there's something not toward going on, then they need to be able to show that they received the declaration, they made some further inquiries, and keep a record of this on their books. Now, there's some areas of concern, quite a few areas of concern, I would say. One of them is, whilst beneficial ownership has been defined by the Act, and as we know, it's the natural person on whose behalf a transaction is being conducted, or the natural person who exercises ultimate effective control. The term beneficial interest has not been defined, and this may cause some issues in terms of interpretation as it interplays with other jurisprudential interpretations. For example, it might have tax implications and BAR implications, but we'll have to wait to see what interpretation BAR is going to put on this particular area, but it is a possible area of concern. Now, whilst the Act defines what a corporate body is, in reading the Act, there is some ambiguity in terms of whether this Act was really meant to cover external companies. I believe that the legislators may have wanted to capture external companies, but as drafted, it does not capture external companies. Now, the Act is in force, as we all know, and there are quite serious and stringent penalties for not complying. But no forms have been issued by the Registry. So all of the notices, all of the declarations, the registers, and the returns that all have to be completed have not been issued by the company's registry. There's also an amnesty in effect, as many of you will know, for penalties, and this expires tomorrow. But these penalties that are covered are in respect of post-incorporation documents. So filing of annual returns, notices of changes, those are covered. But it doesn't cover any of the requirements or the penalties of the amendment to the Act. And Section 516A does not deal at all with any of the criminal sanctions that have been imposed by the Act. So the conundrum that we're in at the moment is the Act has been proclaimed as in full force. There are very far-reaching obligations and penalties. The Registry has no prescribed forms, and there's been no word on whether there's going to be a moratorium on these penalties if there's non-compliance. And the amnesty and Section 516A only applies to post-incorporation documents. Now, I want to just go through some examples, practical examples, to see how this is going to work in practice. So let's say you have a company that's incorporated in Trinidad, XYZ Limited, incorporated in Trinidad and Tobago. Its sole shareholder is XYZ, a Barbados corporation, and XYZ Barbados has XYZ Inc., which is a company traded on the stock exchange in New York. What are the reporting requirements in order to comply with the Act? XYZ Trinidad would need to issue a notice to its shareholder, XYZ Barbados, advising that it needs to fill out a declaration. XYZ Barbados will fill out the declaration under 337C1, we call it a C1 declaration, and say, I am the registered shareholder of XYZ Trinidad Limited, but I do not hold the beneficial, I'm not the beneficial owner. The beneficial owner is Mr. XYZ Inc. in New York, which is a publicly traded company. Because it's a publicly traded company, which we know are exempted, that's the end of the reporting requirements for XYZ Trinidad. Now, if XYZ Inc. was not publicly traded, they then would have had to fill out a declaration, which is 337C2, saying, I am the beneficial owner of the company XYZ, and they would have to name the individual natural persons who were benefiting ultimately from XYZ Trinidad. Another example here. In Trinidad, we have a lot of management companies that deal with residential service so townhouse complexes. So in this scenario, you have the Penthouse Management Limited Company, which is the holding company, and then you have the individual townhouse owners, which may be companies or may not be companies. Under the Amendment Act, the holding company, Penthouse Management Limited, would issue a notice to its shareholders, which would be each one of the individual Penthouse Limited companies. Penthouse Limited number 1, number 2, number 3, if you have 50 townhouses, Penthouse Company number 50. Each one of those companies, Penthouse Company number 1 Limited, would then have to fill out a 337C1 declaration and say, I am the registered shareholder, but I don't hold the beneficial interest. The beneficial interest is Mrs. Debra Thompson, who's the owner of the property. She is the beneficial owner. If I were the owner of that property, I would then fill out a 337C2 declaration and say, I am the ultimate beneficial owner of the property or of the company. Now, you see Mr. Blogg down there? Mr. Blogg doesn't own his property in the name of a company. He owns it as Mr. Blogg. It's his house. The only declaration that would need to be completed in that instance is the C32 declaration, in which he says, I am the registered owner and I'm the beneficial owner of this property. So I wanted to look at a few of the international approaches. There's no one approach. It differs depending on the jurisdiction. The definitions are different for beneficial owner in some of the jurisdictions. The exemptions are different. The scope and the extent is different, and the penalties are different. So we just look at a few of them to get an idea or a grasp of what is going on internationally. So in Canada, the law was amended in December 2018 and became effective in June 2019. A company must maintain a register of information of individuals who have significant control over the organization. And significant control means any amount of up to at least 25% voting rights. Failure to comply holds a fine of 200,000 Canadian dollars and imprisonment for 6 months or more. And again, like in Trinidad, public companies are exempt. Now, the Bahamas, they have a Beneficial Ownership Act, and it establishes a secure search system database. Unlike Trinidad, when you submit information to the company's registry, as we know, you can do a database search. So once information and declarations have been submitted, we don't know the use to which it is going to be put, but the public, Joe Public, will have access to that information in Trinidad. In the Bahamas, it is a secure search system database which is managed by a registered agent. So a particular individual is managing this secure database. In the Bahamas, the beneficial owner is essentially the natural person who ultimately owns or controls the legal entity, and includes a natural person who directly or indirectly controls 10% or more of the shares. The exemptions in the Bahamas are listed organizations that are listed on the stock exchange, a legal entity that is regulated, bank, trust companies, investment companies, insurance companies, or any one of their affiliates. Failure to comply in the Bahamas is a penalty of $40,000 and imprisonment. But more interestingly, there is also a penalty on that gatekeeper. So if the gatekeeper is negligent in any way or hasn't declared, that person is liable also. In Jamaica, the Companies Act was amended in 2017, so they're ahead of the game, they're ahead of us, and it came into force in 2017. The obligations include information on beneficial owners on registration. So at the time of registration, you are required to declare beneficial owners in Jamaica. And every year, when you complete your annual return, you also have to update and provide information on beneficial owners. The prescribed forms for the Articles of Incorporation and their annual returns have all been changed and amended to include space for this information to be included. In Jamaica, a beneficial owner is the ultimate owner or controller of more than 50% of the shares, or 50% of the voting powers. Foreign companies that conduct business in Jamaica are also required to disclose the beneficial owner. And the fine is summary conviction or not exceeding $500,000. Now, public companies in Jamaica that are not listed are also required to provide information on the ultimate beneficial owner once they hold more than 25% of the issued shares or 25% of the voting rights. Barbados. Barbados commenced in May 2019, and it amended its Companies Act so that the annual returns would include information regarding the registered shareholders and beneficial owners. A beneficial owner in Barbados is defined as an individual who ultimately owns control or who exercises ultimate effective control. And it also includes trustees and legal representatives. In Barbados, failure to file an annual return in the prescribed form, there's a penalty. It's $10 per day up to a maximum of $3,000. In England, in the United Kingdom, they have introduced a Small Business Enterprise and Employment Act, and it's one of the first countries to implement this. There's also a People and Significant Control Register. And failure to provide accurate information on the People and Significant Control Register carries with it a criminal offense. However, in England, Companies House has taken the approach that it's going to offer more of a helping hand. So they give a lot of advice to their companies rather than enforce the penalties. So their role right now is to encourage persons to provide the information, hold their hand, and show them how it should be done, rather than penalize them. That has been their policy, rather than enforce, to hold hands to get the information into the system. In Trinidad and Tobago, we're at the very early stages, and the main duty, I would say, of all of us is that every single shareholder and beneficial owner needs to become as familiar as possible with the amendments to the Act. We don't know how or when the registry is going to get its act together and issue the forms. We don't know what's going to happen at the moment because the Act is in force. So anybody who hasn't complied at the moment is potentially liable because the act is in full force. Companies need to get themselves in a position where they are compliant ready so that whatever takes place, they can deal with it. It's really unclear what the registry is going to do in terms of publishing information on ultimate beneficial owners. We don't know if they're going to introduce a second layer so that you cannot just go online and search the database to gather the information. We don't know. So there needs to be some lobbying, I would suggest, and also perhaps some amendments to the Act to neaten it up and tighten up certain areas. But my advice at the moment for us here on the ground is to get ourselves ready and put ourselves in a position that we are not exposed, we're not exposed in our companies or any of our directors or officers. I hope that I've enlightened you a little bit more and that you will now be eager to gather much more information to make yourself and your companies compliant. Thank you.
That's a lot to digest. But I think very succinctly put, are the presentations going to be available? I guess everybody has Hammersmith's number or can find it, is what Glenn wanted me to say. Well, to discuss the implications of this, we have a very distinguished panel, which will be moderated by Mr. Nigel Romano. Nigel, I'm not sure what title to use, but Director CCGI. All right. So may I invite the panel up? We have Ms. Angela Leloy, Donna Marie Johnson, and of course, Ms. Bharat Thompson. And so I hand you over to Nigel at this point in time. And just a note to say thanks to the gold sponsor, CTS College, for helping us make this happen.
I'm going to stand a little bit. My only purpose here really is for gender balance. You all realize that, right?
Serious imbalance.
Serious business. This is about following the money, basically. And this is about getting Trinidad and Tobago a lot more compliant with the whole AML KYC regimes across the world. The unfortunate thing is that we are being penalized when we really shouldn't be. I mean, to be classed with Pakistan and Syria and failed states is not somewhere you want to be. But when people are doing business across the world and when banks are dealing with businesses across the world, they look at FATF and CFATF and these kinds of the reports coming out of these bodies and the algorithms going to work, because nobody can actively monitor these kinds of stuff on an ongoing basis. So the algorithms go into play and the red flags go up and doing business becomes a lot more difficult. So this is another small step in the right direction. Fanta, I think we have to have a whole conference just on how we comply with CFATF and get a lot more of those 40 recommendations ticked off, and we need to get serious about it. But, as I said, this is about following the money. And and I looked at some of the documentation that was prepared. And the first question I have for the panel, and you can choose to answer, whoever, is how, based on the practitioners at the table, how many of our companies that should be complying do you believe are complying right now? Tomorrow is the deadline.
If I, as far as I'm aware, for example, our own clients, we've been awaiting the prescribed forms. As a consequence, we've not, our clients have not submitted any documentation in relation to this new act. And we've been following up with the registrar, and as of earlier this week, she said to me, well, I was told that the prescribed forms would be ready by next week. So that's my experience.
Debra?
We issued bulletins to quite a few of our companies, and quite a few of our companies proactively wanted to do something. So we actually developed notices, declarations based on the requirements of the Act, and returns, and sent them out and asked whoever wanted to have these completed, they could. And a number of our clients did actually issue the notices. They got back declarations from their shareholders, and we did letters of return to the registry. And we spoke to the registry, and they said they had a number of other clients who had done that as well, and they had files which they'd now opened as a depository for that information, because they couldn't be filed because there are no prescribed forms, but they have a file that they've held for companies which have tried to comply. So it goes to from two extremes. You have those that are saying, well, I'm not doing anything because the form is not out, to those companies that are trying to be responsible and have actually completed the steps.
But if I may, I was also told, because I asked about that, in terms of the correspondence that have been issued, and I was told that it's merely correspondence. It's not filed forms.
Yeah, it's not bad.
Yeah, I would agree that it's a bit of both. Yeah.
So there is a kind of people trying to do the right thing, but doing the right thing is not possible because the prescribed forms have not been. So this whole question of bearer shares and stocks, warrants and all of that kind of stuff. The other question that came to my mind was how many companies in Trinidad and Tobago actually issue share warrants or bearer shares or instruments of ownership, let's call it that for want of a better term, that would be caught by that section. Angela, you want to take that one?
Well, I will tell you, I think in my career, I have most probably come across that like once. And I've been here a long time. Okay, so it is really, really very rare.
What about you?
And bearer shares are illegal in Trinidad. You're not allowed to issue bearer shares.
That's
in
correct.
Trinidad in any event.
So that's not an issue. So the issue here really is people complying with the beneficial ownership and the declaration of beneficial ownership. Okay.
So far.
So Angela, you have just joined the panel. What advice would you give as from the corporate secretarial viewpoint to the audience with this entire regime? And then I'll ask Donna to the decision.
Yeah, I'm the oddball here, right? Stuck between lawyers. But I think the fact that you really want to know who the beneficial owners are is important. And I really go back to a bit of history. I don't know many of you who would know Fernand de Verteuil really was what I consider a tax brain. And I always remember him saying, now Angela, the important thing is to know the beneficial ownership and where that is. He was always very clear about that. So, of course, I think you would have known in the past there were a lot of companies that were formed abroad, like in the Cayman, etc., where I think there was the veil under which one hid who, in fact, was the owner. And I think there's so much more transparency today that, and I think that's the way we need to go, particularly in light of money laundering, which, I mean, is really very prevalent. So, yes, I think the fact that this is calling to be truthful and really the onus is really going to be on the people who are behind the companies to come forward and declare. And it really would be a way, I think, of helping the FIU in getting to know who is behind transactions.
I would recommend as well that if there's any issue with regard to, who is the beneficial owner, you should in fact seek advice, legal advice from your attorney to give you some guidance in relation to that.
Angela, you said something. You said money laundering is very prevalent. You want to expand on that?
Well, I mean, I'm going to go back to Francois, who I think is on leave, right? She is really, I've listened to a couple of talks and I guess informally talking with her, there really is information that indicates transaction-wise that things are happening, but of course, what we don't find is anything coming to the fore. But I'm not the particular person responsible for that.
But do you think that the lack of understanding who beneficial owners are a factor in not being able to follow the money?
I would think so, definitely.
Donna?
I'm not so sure.
Explain.
You're putting me on the spot.
Of course.
That's what I'm here for.
In terms of money laundering and terrorist financing, my own view is that individuals generally know what they're doing and what the ultimate objective is. So I really don't think it's a lack of understanding of who the beneficial owner is.
You need the evidence. You need the evidence.
Yeah, you do, but still.
Yeah, I think we're quite sophisticated in Trinidad, and I think we have things structured in a particular way for a particular reason. So I think there's going to be a lot of resistance in terms of complying with the amendment. I think ultimate beneficial owners know who they are, and they know why they are not the registered shareholder and named on any of the documents. They know why. So I do think there's going to be significant resistance.
So non-compliance.
Through non-compliance?
Yeah.
Through non-compliance.
Really? I'm surprised.
Yeah, well, I mean, that's what that's implying.
Yes, it is. I mean, so you are saying that there are many companies in Trinidad and Tobago where the registered shareholder is not the beneficial owner?
Absolutely.
That's quite interesting.
Absolutely.
But the implications are very serious for not complying.
The implications are serious, and that's where what the registry is going to do and whether the whether there's going to be enforcement is what is going to be relevant in terms of how compliant the public becomes.
Yeah, like everything else, the enforcement and the application of sanctions are going to be very critical to ensure that there is teeth to this legislation.
Well, that is not a sham, exactly.
Exactly. So I would say that as somebody who has just come out of our banking system, that banks in Trinidad do quite a good job reporting. The enforcement is a whole different matter. Let me go elsewhere. You spoke to the whole question of using this data, collecting this data, the manner in which the data is captured, and the way the data is analyzed and used. What thoughts do you have about that? Assuming that some people are going to comply, the way the data is captured and the way it is used, and I would imagine that the form in which that data is captured will facilitate or hamper the analysis. What thoughts do you have on that? I know you're not techies, but maybe we'll go out to the audience and get the technical view. But Angela, I'll start with you.
How the information will be used?
How it's captured and used?
Well, I think to the extent that information is given to you, it has been captured, whatever has been given to you. At the end of the day, like in everything, information will pass to the respective body that it needs to go to, and what that body does with it, I think, is where the issue is. I mean, if I were to look at what's going on with the amnesties right now, just like everybody is rushing to get whatever they need to get done simply because they will get away from penalties. But I did have a conversation with the chairman of the Board of Inland Revenue on something, and I will repeat her words. She says, let me tell you, after this amnesty is done, and we have set up the Revenue Authority, there will be no mercy going forward. So, in other words, really what the people at the top or have the power to do what they need to do is whether they really truly act. I mean, we I think as people can only get the information and send it, but we are not the authority to take the action. So it's really the people who have the power to do what they have to do, the extent to which they really pursue it.
So the lawyers here and you deal with the registry, right?
Mm-hmm. Yes, registry.
How easy or how difficult it is to get information or data out of the registry today, if you had to?
Well, in terms of obtaining filed information, you can search yourself. You don't have to go to the registry.
Yeah.
What I will say, though, is sometimes their records are not up to date, and therefore you may have to go in personally. But if you try to call any one of the officers, they generally are quite helpful in giving advice or giving you information. They are quite helpful on the ground.
And how do you access the information today? I mean, do you go in electronically?
Yeah.
Yes. You can stay in your office and search electronically. You have to pay to register.
Right.
But once you register, you can search their records. The only problem is if it's not up to date, which does happen quite regularly. So documents are filed and they don't upload it into their system. And therefore, when you go and do a search, you wouldn't get the latest information. But if you find a company where their information, say, only goes up to 2017, and then you call the registry and you ask them, look, I'm not getting full information. You call or you go in person. They are quite helpful in searching through their records and saying, well, yes, X, Y, and Z was filed, it is here. You can come in and look at it. So they are helpful in that regard.
And you can't file electronically?
No. We haven't reached that stage yet.
But should we be aspiring to that stage?
That would be, I think that would be great if that could happen. But honestly, I agree with you that they have been very helpful, and it's easy to really go online and get the information you want. They most probably need to get like the work permit people, which you can all do that online. Send it in.
We should be doing a lot more of that. Hopefully, iGovTT may be able to help in that regard. I think I want to open it up to the floor for questions, and let's see if we can provoke some debate. Your mic? All right.
Okay.
Hi, good morning, everyone.
Good morning.
So I'm here in my capacity as Assistant Secretary for the Massey Group, and we have a few of the company secretaries here with us
this morning. We have had quite a challenge with the implementation of some of these changes to the Act. So I have one question actually two. One question for Debra. In your presentation, when you were speaking about the beneficial owner's obligation to send that notice to the to the company, I think it's 337C1. It says if a shareholder is not the beneficial owner, he or she must send that information to the company within 30 days, right? So my question is, if that shareholder is also the beneficial owner, do you think that there's still an obligation to send the information, or they don't have an obligation to do anything?
Yeah, so
That's
there
my
are two
first question.
sections that deal with the declarations, 337C1
Yeah.
and 337C2. C731C1 deals with the registered shareholder. Now that person can be registered, as you say, and have the beneficial interest, or registered and not have the beneficial interest.
Yes.
C1 deals with where they do not hold the beneficial interest. What that individual would have to do is fill out a 337C2 declaration, because they are the beneficial owner. So they would fill out the C2 declaration and say, I am the registered and the beneficial owner.
Okay, so there's an obligation on shareholders at all times, on either 33C1 or 2.
Yes,
Great.
correct.
And then the second question that I have, in your example when you were using the companies as legal entities with the ultimate parent, so we had a company in Trinidad, the parent of that company was one in Barbados, and then you said the ultimate parent was one in New York. In your presentation, you said that when you get to that stage, XYZ in New York, I think, because that company is listed, that's the end of it there. But I guess I need to go further. Because the Act asks for a natural person, or if not a natural person, the person who exercises ultimate control, and in our Act it actually says the managing director. Who should we put? And I'm asking this in the context because we've had a challenge in Jamaica because we have some interest there as well. And in the Jamaica legislation, it says the person who exercises ultimate effective control. But in our Act in Trinidad and Tobago, it went further, and it actually said the managing director, and the Jamaican Act doesn't have that. So for the XYZ Inc., Trinidad going all the way up, what does the XYZ Trinidad company, who does the XYZ Trinidad company name as its beneficial owner? Because the Act specifically says a natural person.
Right. So the Trinidad company will have to issue the notice to its shareholder. So the Trinidad company is only issuing the notice, right? The shareholder of the Trinidad company is, well, we'll use Massey. So Massey Trinidad issues a notice to its shareholders in Barbados, Jamaica, or wherever. The shareholder, so the Trinidad company is only issuing the notice to the shareholder. The shareholder in the Caribbean jurisdictions, they would have to say who the ultimate natural person is, and they have to go all the way up the chain of Massey, and I don't know the Massey chain right in my head.
And just like your example, when you go all the way up, we have Massey Holdings, which is a listed company.
It is a
listed company.
It's listed.
Yeah. So
Right,
when you
so
go
but if it's a listed company,
There's nothing to do.
the Act specifically excludes companies that are listed, and therefore, even though there might be an ultimate person, the purpose of the Act is to expose information on ultimate beneficial owners. But listed companies have their own regime, so that information is going to be available, and that is why you can stop at that level. It's not the person's getting away. It's a listed company, so that information, you have to provide that in some other forum. May not be under the Act, but you have to provide it. So for Massey's purposes, you name that listed company, but you would need to say, in my opinion, that it is a listed company. Because otherwise, you could come across as being non-compliant.
Yeah, and I think that may be our challenge.
Let me just ask, are these listed companies listed on stock exchanges in any jurisdiction, Deborah?
Yes.
Yes.
So
Because-
New York
yes,
Stock
yes.
Exchange,
Yes.
London Stock, okay, good.
Absolutely.
Okay,
yes.
thank you all so very much.
You're welcome. Question, go.
We're getting away with it.
Yeah.
Morning.
Good morning.
I'm a director in a homeowners association,
Homeowners.
non-profit, no money, dead in the water, dozens of shareholders, shareholders who are companies. So this, to me, is a paperwork nightmare. We are more than 25 shareholders, of which maybe 1/3 is companies. Basically, what I want to know is, since we have no forms, what basic information should be caught? And that is, in light of the fact that, like, for example, annual returns captures name, address, and profession. Is that enough information to capture at this juncture, since we have no forms? Or what do you recommend?
Well, according to the Act, you have to provide enough information so that you can identify who the individual is. So, for example, giving a work address or an address where the person may no longer be, you still can't identify or find the person. It has to be sufficient information, according to the Act, that you could identify the person.
Identify and find.
And find. I don't know if the other panelists have any other different views.
The thing is, I agree with that, but I am of the opinion that the regulator should provide some guidance to the public in relation to certain aspects of this legislation. For example, that issue that has just been raised, and secondly, you mentioned earlier the reasonable efforts by a company. And exactly what is that? I think it's absolutely necessary that the regulators give some guidance and says, okay, these are the things that you have to you pay attention to or you consider, and then it's left to the company to determine the extent to which they go to obtain the relevant information. So I think guidance is absolutely essential.
There are gaps, and it's correct. We don't know.
So let me ask a different question. Is the law association, and I'm assuming you're both lawyers, so are you in conversation with the regulator about the gaps and advising them of the need to communicate with shareholders and company secretaries and the like?
We have had conversations with the registry and the legal officers there in terms of certain of the initial areas of concern, and they are aware of some of these areas, is as far as I will go.
Personally, I have not had any discussions with them.
I would say, I would agree with you that is the situation. They know they have things, but like everything else, is like, I know we had a practical situation we had, and it's a simple form, and you get a simple answer from the BI. Oh, we're out of those forms. I mean, it's like, so you can imagine trying to get a form.
Yeah. Good morning, Doralan Beckles-Lamont. I have two questions. They are related to the obligations and criminal penalties to directors and shareholders.
Related to what?
Penalties.
The obligations and criminal penalties for directors and shareholders. 1, directors. There is no obligation in Trinidad and Tobago for persons to agree to be a director. So a person could find themselves in a small company as a director without knowing. That's just 1. 2, I have seen bylaws in which the major shareholder can by will, dispose of their shares. So, for example, a minor or young person can find themselves as a shareholder. Those, to my mind, are gaps we need to address. Thank you.
All right, so there are two questions. One, directors becoming directors without their knowledge. I'm not sure how that will happen, but the other one is you becoming a shareholder by will, being a child of the owner.
Beneficiary.
Of the beneficial owner. So let's...
In relation to your first question, it's a little unusual for me to hear that a director can be appointed a director without his knowledge. Normally, he has to agree or consent to sit on your board. That's been my experience.
Agreed.
So
Yes.
There are small companies in this country where mother, sister, brother, father, grandmother can find themselves as a director without even knowing.
Okay, we understand the context. I suppose the CCGI has more work to do because nobody should accept a directorship given the onerous responsibilities. Let's hear from Free.
I think Darlan is perfectly correct. I mean, that is a gap in our legislation.
Use the mic.
I could form a company tomorrow, and I could name people as directors, and they are directors. There is no requirement under our act that that form requires the consent.
Oh.
No. For
I
non-profits,
guess the
I
point
believe they
is,
do.
there's nothing in the act that says
Yeah,
a
there's
director
nothing
is
in the
supposed to first.
But I think part of the issue that we face, and in preparation for this, I was listening to the Senate debate, and that is that we have made companies so easy to form. So you want to set up a business, so you say, well, there's this limited liability thing, so I'm going to set up a company. And as Darlan suggested, well, gosh, you need two directors. Well, mom and dad, you be my directors, and you start running your business. For a long time, you don't file returns until you hear about this amnesty, and you have to file returns. So you hire an accountant or your lawyers, and you ask them to file the returns. You don't keep a share register. You don't keep records. So what we have is a large segment of our corporate population, which are very small companies, who don't have those things in place. And these are the things that people will need to start doing now. Because what you didn't touch on, Debra, in your presentation, in addition to all of this, every time the company issues a share, that information on the beneficial ownership has to be filed in the company's registry. Every time a share is transferred, filings have to be done by the transferor, by the transferee, by the company. I mean, I really hope they get electronic filing because this is going to be forests chopped down to supply all this information. So it's really, there are gaps in the Companies Act that need to be addressed, and that's one of them. Thank you, Dora.
All right, so now we understand the context, and I see a lot of nodding around the room. But what I think we're dealing with here is the informality that is a lot of people who run businesses, the informality surrounding the regulatory side of the affair. And I think one of the messages that has to go out is that informality can get you into a lot of trouble if you're not careful, and may jeopardize your ability to transfer the ownership and that sort of stuff when it comes. Debra, you have any additional comments on that?
No, I think it's very true. We do have, and from the reaction here, we have a lot of companies that are set up in an ad hoc matter. and there has not been compliance, and they may not even be aware of the penalties and the obligations. So I do think that CCGI has a lot to do to get that information out there, so that people are not, grannies and mothers, old parents are going to find themselves in a lot of hot water.
Yeah.
The second question.
Yeah, I was about to say a second.
Oh, with regard to the transfer to a beneficiary, that's the question, right, Dorolan? Where is she?
Yes, Donna Marie, the context really is that sometimes we have bylaws in small companies which they make provision for persons to transfer their shareholding via a will. So the person who is making the will and who is the shareholder before the coming into force of this act may have passed. The will may not have been probated, and you have minors who are the beneficiaries. To my mind, that creates a loophole, because I have seen that situation.
But exactly what is the question, though? I'm not
Yes,
following you.
because the obligations, they make provision for the shareholders to register. And I am saying that the minor does not yet know that they are a shareholder, or can they do it even if they are minor. So, and the will has not yet been probated to place the shares in their name, so that no register shows it. So there is a step and a loophole that is missing there.
Well, the process, as I understand it, is that, okay, somebody dies, somebody makes a will, dies testate, okay,
Yes.
and devises shares in a company to X. A grant of probate is obtained in relation to the estate. Once the grant is obtained, you then have to do a share transfer. The legal personal representative would transfer the share to the named beneficiary. And in accordance with the current legislation, the company is required to submit to the Registrar General within, I think, 30 days of the registration of the change, information with regard to the transfer of the shares. Does that answer the question?
Yes, I think what my mind was drawing to, what I was thinking about, was the fact that persons who are shareholders from the coming into force of the Act must place their names and file a return with the company's registry.
But in terms of the named beneficiary, right, he is not a beneficiary until the transfer is effected. All he has is a chosen action to call upon the legal personal representative to do what has to be done, right? So until the shares transferred to him, I don't think there's any obligation on him to submit any information. I don't know, Debra, if you agree with that.
No, I do agree, but also, if it's a minor, there should be a trust in place.
Yeah.
And the trustee, under the Act, has the responsibility of reporting and accounting.
In a case like that, wouldn't the trustee be the beneficial owner?
The
Because
trustee is the one who has
the
to
trustee has decision.
prepare the
No, but he is
declaration.
illegal. The trustee would be the legal owner, and the minor is going to be the beneficial owner. Right.
But if the minor can't make decisions with respect to how the thing is run, how could he or she be the beneficial owner? It's for me, in this case, the person who has control kind of in effect owns, and that's the person we're looking at under AML KYC.
But the Act does deal with trusts, and it says
Exactly.
it's the
trustee, yeah.
who is responsible.
I noticed when we were looking at the other countries or islands who have implemented this beneficial ownership, that apart from England, from the British model, I didn't see whether there were any penalties for inaccurate or false information provided. And I think that's a loophole, because trust a Trini to find a way to beat the system. And one could just send the information and put in names, addresses, and there, from what I gather, our local act does not provide any penalties for false declarations. Is that so?
What the Act requires is that reasonable efforts are made by the company. And they have to be diligent to the extent that if you know that information in a declaration is not true, you cannot just rubber stamp it. You have to verify to some extent that that information is correct. And that is why it says that a company would not be liable for the bona fides, relying on a bona fides declaration. So if a company or the body corporate or the officers are aware that a declaration is absolutely false, because they've been dealing with Mr. X all the time, telling him, put the money here, do this, give me, and then they get a declaration saying Mrs. Y is the beneficial owner. And they're very sure that they never dealt with Mrs. Y ever, a housewife or a mom or something. Then the company does have a duty to dig further. And remember, the company also has to, the registered shareholder has to fill out its own declaration saying, this is the beneficial owner. So unless everybody is in cahoots, this is aimed at trying to weed out that sort of dishonesty. But of course, as you say, this is Trinidad.
Yeah, so what I'm getting at is that you're saying then that the company that receives this information is required to perform a level of due diligence to verify that that information is accurate?
The Act says that the company must make reasonable efforts to ascertain who the beneficial owners are. We don't know what reasonable efforts are because it hasn't been tested as yet. But there's room for interpretation that by actually using the word reasonable efforts, it means that the company can't just be a rubber stamp. That whatever they get in, they send it off when they know that it's not accurate.
I did in rereading the Act in preparation for this, had that same question, because you have that subsection which requires the company to annually verify information on record at the company's registry through filing of its annual return. So there does seem to be a sense that the company is being made the gatekeeper here, and I think you use the word certify in your presentation. So that there does seem to be a sense that reasonable efforts and verify are not necessarily the same thing. So there is potential here for an interpretation that suggests that companies may have to go further in terms of identifying, ensuring that the information provided to them is in fact accurate.
Faye, can you read that
section
again?
This is 337B5. Is there a B? Yes. 5. A company shall annually verify information on record at the company's registry through the filing of its annual return. It's a kind of funny language because it says through the filing of the annual return, but it does use the word verify.
And it's verifying the information at the company's
on record
registry.
at the company's registry.
Yeah.
So that's everything that you have filed in the registry.
But at this time, the annual return at this time does not include any further information. Remember, the return that's being filed in compliance with this is a separate return. We don't know if these annual returns are going to be amended. We have no idea.
Yeah, but the annual return still includes information on registered shareholders. So there's a certain
Correct.
amount of information.
Yes. Yes, you're correct, and you're
So
also correct.
I'm just pointing to that the company does have a responsibility, and there is provision under the Act, the overriding Companies Act, that where you file misleading or inaccurate returns, that is an offense, and directors and officers of the company can be liable for that offense as well. But there does seem to be a loophole for the actual beneficial owner who files a misleading, or the registered shareholder who files a misleading information.
Well, remember, there is a fiduciary duty on every officer, on the directors and the shareholders and the secretaries of a company to act in the best interest of a company. So in filling out the annual return in any event, before this, putting false information on a declaration has, consequences.
Yes, but okay, I guess the difficulty is how far do you have to go? So are we now, as company secretaries, going to have to ask for utility bills and ID and those kinds of things? I think that is the concern as to where this could potentially go, and demonstrates the need for further information and guidance to be forthcoming on how this is done.
I agree with you completely.
Yeah, and I think we all agreed earlier on that there needs to be guidance issued, because you're right, how far do we go? How far does the company go? And the regulator has to issue guidance.
And I think, again, all this has to be read in the context of anti-money laundering and knowing your customer.
Mm-hmm. Yeah.
Because as a company, as a company secretary, you have I think you have an obligation to understand who you are dealing with and who you are acting for, so whose interests you are ultimately serving. And that is the interest of the beneficial owner, the person who is going to benefit from the profits made from the company or the assets owned by the company. So again, be mindful in the context of anti-money laundering and know your customer. In the banks, when we onboard a client, that due diligence, in addition to all the utility bills, etc., the most important due diligence dealing with a business is to understand the business and the kinds of monies that we expect, that we reasonably expect to be flowing through that business. And if you see flows that suggest otherwise, you have an obligation to report. So I think what we are doing here is extending that to beneficial ownership. Questions? Everybody is crystal clear and scared. We have 2 questions. So.
Hi, good morning. I'm from the sports company of Trinidad and Tobago. The sports company.
Okay,
yes, so our sole shareholder is, the Ministry of Finance. So we're kind of wondering if it is that we would have, this amendment does apply to us, if it is that we would have to file out the requisite form and, to determine, obviously our beneficial owner is the government, so.
Well, your beneficial owner are the people of Trinidad and Tobago.
Yes.
Yes, a declaration will be required to be submitted, and under the Companies Act, it clearly identifies corporation sole as an individual. So that is in terms of when you file the declaration, the corporation sole will be identified as the beneficial owner.
Does that answer your question? It's the corporation sole on behalf of the people of Trinidad and Tobago.
So I do like your question behind there. In fact, the change of directors with the company's registrar and the shareholder listing only requests name, address, and profession to be lodged. And it does not require a signature from those respective people. it only requires one signature to get it done. But my question now would be, forgive me.
I can't remember what the question
You
is.
can come back when you remember. Yes, Glenn.
One concern I have is that, or one of many concerns, is that there are a lot of companies out there that, were operating at some point in time, and they maybe have not been struck off the register, but they're not really operating anymore. The owners, may have passed away. They might have had a share or two in their name, may not have done a will. They have no ultimate beneficiaries named, and no one has applied for probate. You're going to have a situation where you have a company, there's no one to go and request the information, there's no one to respond to the information, and there must be thousands of companies like that out there right now. You also have a number of companies where, in recent years, who have, for one reason or another, decided to delist from the stock exchange, both here and in some of the other Caribbean territories. So by that, they are no longer exempt, all right? Many of them technically are still public companies though, even though they may have deregistered or no longer listed. Many of them again are in that situation where they have minor shareholders. So they have hundreds or thousands of shareholders. Some of them are on their registry. They send notices, they never attend meetings, they never show up. And you're now going to send them requesting to provide information if they are the beneficial owners. Well, they never show up at meetings, they never respond to anything, so likelihood is, the mail is probably not even going to their correct address anymore, or they've died years ago, and so on. Is just sending those letters out to your shareholders, to your many shareholders, going to be viewed as reasonable efforts to detect who are even your shareholders, let alone who are the beneficial owners in a situation like that? And how do you think the authorities will deal with a situation like that? And how can the company show that they have done what they need to do to comply?
Yeah. I mean, I really don't know what position is going to be taken. But at some point in time, the directors of the company, well, if there are directors, I mean, somebody has to be giving instructions annually in terms of filing returns. But if no returns have been filed, exactly, after a while, then steps need to be taken to probably strike the company up. If it hasn't been doing business at all, then that would be the safest thing to do. But nobody knows what position is going to be taken.
But the thing is, the registrar as well, he is authorized after a certain period of time, he is authorized to strike companies off.
And they have done it.
It hasn't been done
and they have done it.
Yeah,
they have.
So the governance is important. You have two questions.
Yeah, I remember. So I remember the question, and that is when a director just comes to a board and they inherit something, right? Basically, they inherit what was done from before. And through the process of discovery, during a period of time, you might find that there's been a lot of mess. For example, shareholders that are listed are not shareholders. They don't even own the right to that shareholder. They're not legitimately a shareholder. How does that reflect in terms of penalties?
But the thing is, once you're to be registered on the company's register of members, you're supposed to be issued with a share certificate. So it's kind of strange to me to hear, what you've just described.
So the individual has a share certificate, but they're not the owner. And they're not the ultimate owner. And they're not the owner of the property.
They're named on the share certificate.
They're named on the share certificate, but they're not the owner. And they're not even the beneficial owner. Yeah, it's just the service companies. And then also too, how does it impact it's crazy.
Yeah,
You know?
the older service companies, when you sell the first, you develop, you issue shares to all these owners. And in those older companies, a lot of the time, properties were sold without transferring the shares. So you may actually have a number of persons on your register who are not the owners of the shares. But you will just have to write to those registered shareholders and you interact with them and show them their responsibilities to identify the beneficial owner. So hopefully that will generate all the transfers that are necessary to bring your register up to date. Well, your job is to take those reasonable steps to verify.
Exactly.
So once you have put that in action, you should be covered.
There is cleanup that has to take place because those share certificates need to come in, they need to be cancelled, new ones need to be issued. But there is that cleanup exercise that now has to take place.
Yeah, Maureen, my name is George John from Contemporary Security Concepts and Solutions. A lot of discussion taking place, a lot of brainstorming, a lot of ideas. What next after this meeting? We talk about the regulators giving guidance. Are we going to have a discussion with them, the board, going to have a discussion with the authorities to ensure that the guidance come out? The second question is, my friend here talk about some companies not making money. What about the sole trader companies that is not making any sort of finance as the returns relates to the end of the year? Is these companies incorporated in this act? Thank you.
So let me just clarify. The second question is to do with sole traders.
Yes, sole traders, sole
These
trading
are
companies.
not incorporated companies.
Hello?
Are they incorporated or are they not incorporated?
They're not incorporated. They're registered but not incorporated.
All right. So it's just trading as companies, basically.
Yeah.
Sole traders are not covered under this existing legislation. It's companies, incorporated entities.
This legislation is to deal with incorporated companies, locally incorporated companies.
And the first question is communication with the regulator.
Mm-hmm.
I think we have some work to do there. Mm-hmm. And I mean, all the professional bodies maybe should do some more lobbying and some more educating to get the regulator to appreciate what we're hearing on the ground. So I will certainly be working through the CCGI and with ICAT, with the Law Association, with the Bankers Association to get some traction there. We have 3 minutes. Any more questions? All right. Thank you all very much. Nirad, you want to close up?
No, it's not Nirad.
Or Faith. Sorry.
Thank you all. It's now my duty to try and bring things to a close. I would like to take the opportunity to thank AmCham, our partner in this venture, and for the members of the board of directors who have attended here today to show their support. I would like to thank the directors who are present of Caribbean Corporate Governance Institute as well. And a special thanks to our gold sponsor, CTS College, without whom we would not have been able to bring this off. I would like to thank our speakers and panelists, Fanta, Debra, Angela, Donna, and our moderator, Nigel. I'd like to thank Kamala, our CEO, has more than enough energy for us all, and our admin support, all of whom contributed to us being able to pull this event together today. And particularly, I would like to thank you, our audience, our members who have joined us, our members-to-be. Thank you very much for joining us, your insightful questions and your suggestions. Thank you all, and I wish you a pleasant day.